Hi, this is Casey Vose for EDL 850. I'm going to be talking to you about tort liability. Tort liability is a wrongful act or violating someone else's rights. There's two different types. There's intentional and unintentional tort. Intentional is the intent to harm someone you know what you're doing to them, such as assault, battery, slander, invading their privacy, things like that. The unintentional tort is the negligence. It doesn't require proof of intent. School personnel acted improperly in a situation involving a student. Teacher leaving a class unsupervised, things like that, that they are very unintentional with their negligence. Some school cases involving tort liability. The first one is Hoyam versus Manhattan Beach City School District. Michael was a 10-year-old boy that left summer school early one day and was hit by a motorcycle, causing serious injury to himself. Michael had left school property and was hit in a public road. Michael's mom and his claim about the accident happened because the school's negligence of their supervision with him. She was not notified that he had left school early. The case was dismissed, stating that it is unfortunate, but the school is not liable once the child left the school's property. Some reactive measures I would take is work with my legal representation through it, talk with my staff, students, and parents about the safety of remaining at school as well afterwards. The proactive measures, I would definitely review and amend our school policies and procedures in place to follow if an incident like this occurs. Make sure we have a policy in place that if a student was at school and then didn't check in at another period, or the teacher noticed an absence, that they notify the office, and the office can definitely make some arrangements to call police and the parents to find and locate this child. I'd also would talk about this with students and what consequences there are for leaving the school as well. The next case is Mitchell versus Cedar Rapids Community School District. DE was the initials given on this child. They were not given the actual name, but DE was a 9th grade special education student with an IQ of only 67, and MF was a 19-year-old special education 12th grader. They both left school early, skipping their 6th period. DE had asked mom's permission to go to MF's after school, but they decided to skip 6th period and walk there right after 5th period. DE's absence during 6th period was not investigated and looked into like their district policy says in place. Their policy that they already had said that if a special education student missed a period, then the special education teacher would follow up with the paraeducator and with the office, and they would notify parents, and none of this took place. During the time that this happened, MF raped DE in another friend's garage, and that friend watched it happen and then was shooting DE with a BB gun as well. Unfortunately, DE did not report this incident until about 7 months later, at which point her mom went straight to the local authorities. The jury found the school district guilty of negligence in failing to provide adequate supervision of a special education student. The school district had everything in place with their policy. For some reason, they just didn't follow the policy on this one. Some reactive measures would be definitely contact our local representation, collect facts from all the parties involved to the best of their abilities of what they can remember once the claim came about. Some proactive measures, I would review that district policy with the special education teachers, any paras, and any classroom teachers with special education students. That classroom teacher, as soon as the student was absent, could go right to the special education teacher or the office and find out if they'd been there prior in the day. I'd also put alarms on doors that are not the main exit by the office so that they'd make a sound when someone goes out them, to just prohibit students from going freely out those doors as well. The next school case was Barrett versus USD 259, Wichita School District. Alex Barrett was a 12th grade football player that collapsed during his first mandatory practice and died the next day at the hospital. This practice lasted for several hours during a heat advisory day. They did not have full pads on, but they were wearing helmets. The coach took measures to make sure and provided water breaks several times throughout the practice. I think it was every 20 minutes. When the student wasn't feeling well, the coaches allowed him to sit down and told him to get another drink of water. At the very end of practice is when he collapsed. Currently, the case has been reversed and remanded to determine if the defendant's actions amounted to gross or negligence, causing Alex's death as well. It's really an unfortunate event. We'll have to keep watching to find out how that one ends up turning out after it's remanded. Reactive measures, definitely contact that legal representation. I'd put the coach on administrative leave pending the investigation, and I would also cancel or limit practices during these heat advisories, or move them indoors for conditioning purposes, things like that. Some proactive measures, definitely review and change, if necessary, the school policy to limit or move those practices indoors during that heat wave to make sure the next time we are under heat advisory, this doesn't happen as well. I would make sure all my coaches had proper training for heat illnesses and what signs to look for if a player is showing any of those. The next one is Barnett versus Caldwell. And Tony is a high school student and a friend were both horseplaying around in a classroom after the teacher, Mrs. Caldwell, had left them unsupervised. Caldwell asked a neighboring teacher to listen for them as she left the classroom. He fell to the ground with another student on top of him, breaking his collarbone, causing it to lacerate a major artery. By the time the teacher made it back to the room, she called EMTs. They took him to the local hospital where he was pronounced dead. His parents sued Caldwell for wrongful death based on the negligent supervision. The courts ruled in favor of Caldwell, saying her leave from the classroom was a discretionary act, and while she was away from the classroom, the actions were not on her. She did ask the neighboring teacher next door to listen for her class, but that teacher was busy teaching their own class and did not see the incident take place. Some reactive measures would be, again, contact that local representation. I would put my teacher on administrative leave pending the investigation, and I would amend any school policies along these natures. The school didn't really have many policies in place as what to do to leave an unsupervising class if you needed to leave the classroom. So get some policies in place as a proactive measure. That way all teachers know what the policy is and the procedure if they need to leave the classroom when they have students in there, to make sure that the kids are supervised and being taken care of and nothing like this would happen again. The next court case, I'm not exactly for sure how to pronounce that last name, Brockett versus Millard School District. David was a 9th grade 14-year-old boy, was accidentally struck in the head with a golf club during PE. He was knocked unconscious, and then he died 2 days later in the hospital. Unfortunately, in this event, David missed the very first day of golf lessons, where they went over the safety procedures and what to do while other kids were swinging golf clubs. He missed all that. The next day, they just went straight into golfing without reviewing any safety procedures. He had never held a golf club and asked a friend that had been in his group to show him what to do. He backed away as the friend went to swing the club and stepped in, and the club got him on the follow-through swing. The state Supreme Court ruled in favor of the family, stating that if the teacher had provided adequate supervision, and the death would never have happened. In this case, it was a very large PE class. They were split in half. The teacher took the other half of the students, and a student teacher was with the half of students that David was with. The student teacher was bent down with their back to him, helping another individual student, and nobody was supervising the event as it took place. Reactive measures would be contact that legal representation. I would put the teacher on administrative leave pending the investigation as well. So proactive measures, review that school policy. I know the school had a policy in place for the golf, and the teacher wasn't following the policy rules. Definitely need to make sure any teacher that's going to be working with the students, including student teachers, they're very aware of all the policies that the school has. And then also that they review the safety at the beginning of each golf lesson. There was a lot of students in the classroom, and it had to be moved indoors. Maybe it was a day where you don't golf indoors. If it was inclement weather, you skip that day and make it up another day where they can be outside as well. Here are the sources that I use to find all of my court cases and my information. Thank you.